Welcome to The Explainer. Today we're navigating the notoriously treacherous waters of software patenting. Look, if you're a developer, an entrepreneur, or an IP professional, you already know that protecting your software innovations is absolutely crucial. But lately, securing that protection feels less like a straightforward legal process and more like trying to thread a needle in a hurricane. We're going to unpack this complex legal landscape, look at what the courts are actually doing right now, and figure out how you can survive the gauntlet. Let's kick things off with a number that should honestly make any patent owner stop right in their tracks: 95.5%. In the calendar year 2024, the United States Court of Appeals for the Federal Circuit decided 22 patent cases strictly on the substantive grounds of subject matter eligibility. Out of those 22, they found the claims eligible in exactly one case. That is a staggering 95.5% effective invalidity rate for patents on appeal. For patent owners, the Federal Circuit has basically become an absolute abattoir for software patents. So you really have to ask yourself, why is software so incredibly hard to patent right now? I mean, think about it. Software has very concrete manifestations, right? It's stored on physical media, it controls tangible devices, and it actively changes the physical state of hardware. And yet, in the eyes of the law, it constantly gets lumped into this vague category of abstract ideas, even when a claim is written so narrowly that it only applies to one highly specific, real-world use case. To understand this massive disconnect, we really have to look at the rulebook. Okay, let's dive into this by establishing our statutory baseline. 35 U.S.C. Section 101 is what defines patent-eligible subject matter. It broadly states that you can patent any new and useful process, machine, manufacture, or composition of matter. And hey, that sounds pretty inclusive, doesn't it? But here's the catch. The Supreme Court has long held that there are implicit exceptions to the statute. You literally cannot patent laws of nature, natural phenomena, or abstract ideas. And it's that very last category, abstract ideas, that has become the ultimate stumbling block for software. To figure out if a patent violates that exception, courts use the Supreme Court's two-step Alice-Mayo Framework. Think of this as the ultimate gatekeeper. Step 1. The court asks if the claim is directed to an eligible concept, like an abstract idea. If the answer is no, great, you're safe. But if the answer is yes, you are forced right into Step 2. Step 2 asks, does the claim include an inventive concept that actually transforms that abstract idea into a patent-eligible application? In other words, do your claims as an ordered combination amount to significantly more than just the abstract concept itself? And listen, this hurdle isn't just tripping people up in federal court. It is a massive roadblock right at the USPTO level as well. If an examiner rejects your software patent under Section 101 and you try to appeal that to the Patent Trial and Appeal Board, the PTAB, recent statistics show they affirm examiners' Section 101 rejections about 90% of the time. Unless your claim perfectly mirrors a past case that was already found eligible, the PTAB is highly likely to just stamp it rejected and move on. Section 1. The Abstract Idea Trap: Functional and Results-Oriented Claims. So why are all these software patents failing so hard at Step 1 of that Alice framework? Well, courts are drawing a severely strict boundary between abstract information processing and actual, concrete technological improvements, and it almost always comes down to functional language. A perfect example of falling right into this trap is the IBM versus Zillow Group case. IBM had this patent for a coordinated geospatial interface. Basically, a user could draw a custom shape on a digital map, and the system would dynamically update a list to show only properties within that drawn boundary. Sounds really useful, but the Federal Circuit totally struck it down. They ruled that selecting and presenting limited datasets based on user inputs is really just something humans can do manually with paper maps and printed listings. As the court bluntly stated, mere automation of a manual process using generic computers simply is not a patentable improvement. This brings us to a really crucial point. We have to be extremely careful of what's known as the UX illusion. Improving a user experience, or UX, no matter how innovative, slick, or user-friendly it feels on the screen, is just not enough to satisfy Section 101 on its own. If you improve a user's cognitive experience or present data in a much more comprehensible format, but you don't fundamentally improve the underlying functionality of the computer itself, the courts are going to strictly view it as just another abstract idea of organizing information. And this strict enforcement didn't slow down. It continued aggressively right into early 2026 with a series of rapid-fire judicial smackdowns. Take the case against Google regarding web conferencing time shifting. It failed because the claims were entirely results-oriented. They completely lacked the specific physical data structures or algorithmic steps to actually achieve that time shifting. What about Columbia versus Gen Digital? That one wiped out a massive $185 million damages award, simply because the divide and conquer virus scanning method was deemed an abstract computational concept rather than a physical claim limitation. And in Constellation versus LG, the idea of optimizing data transmission capacity failed entirely because the claims just asked for the optimized result without actually outlining the specific algorithmic constraints required to construct it. Moving on to Section 2, the blueprint, structural, and technical improvements. Now, it's not all doom and gloom here. There is absolutely a way through this maze. So, what actually works in the eyes of the law to survive a Section 101 challenge? It really all comes down to the stark contrast between functional, results-oriented claims on one side and structural, technical claims on the other. Eligibility isn't determined by what an invention accomplishes, not anymore. It's determined strictly by how it structurally and algorithmically achieves that result. You literally cannot just claim the destination. You have to claim the exact technical path you took to get there. Let's look at some actual winners to see how this is done. In Unilock versus LG, the patent survived because it didn't just generally claim reduced network latency. Instead, it claimed a very specific structural change to a data transmission protocol, specifically a unique polling field that directly resulted in that reduced latency. Or take the famous EnFish case. Those claims were saved because they detailed a self-referential logical table that structurally changed how memory was configured, allowing for much faster searching. And in ADASA, a patent on RSID tags survived because it claimed a specific hardware-based data structure utilizing a unique bit allocation. Do you see the pattern? These all physically modified data packets, restructured databases, or optimized memory efficiency right at the architectural level. Now, you might be wondering, how does this logic apply to the incredibly booming field of artificial intelligence? Well, recent analysis from IP litigators at Quinn Emanuel shows that AI innovations face very different prospects depending heavily on how they are actually implemented. Specially designed AI hardware like a brand new processor uniquely architected to execute complex neural models faces a much clearer, easier path to eligibility, mainly because it's very clearly a physical machine. But if you're trying to patent generic software algorithms or statistical models that just run on standard, off-the-shelf computers, you're going to slam right into that Section 101 wall, unless you can rigorously prove a concrete improvement to the computer's internal operations. Which brings us to Section 3, the playbook, winning drafting strategies. So how do we take all this incredibly dense case law and turn it into something practical that you can use today? Well, here is your rapid-fire, actionable drafting playbook. If you're writing a software patent right now, you need to preemptively stack the deck in your favor. First and foremost, focus entirely on a specific technical improvement. Does your software make the computer run faster? Does it use less memory? Improve network security? Highlight that. Second, your claims absolutely must explicitly explain the how. Describe the exact data structures and the algorithmic architecture doing the heavy lifting. Third, avoid emphasizing business processes, financial relationships, or human tasks. If it sounds even remotely like something an office administrator could do on paper, it's getting flagged. And finally, do not over-rely on older wins like EnFish or Macro. The landscape has grown way more skeptical since then, and examiners simply won't take your word for it that your invention is just like those rare past victories. Federal Circuit Judge Chen actually laid out an explicit warning that perfectly summarizes everything we've been talking about today. He stated that simply reciting a functional result at the point of novelty poses serious risks. Let that sink in. If the absolute most innovative part of your software, your literal point of novelty, is described merely by the result it achieves, rather than the intricate technical mechanism that achieves it, your patent is standing on incredibly fragile ground. Which brings us to our final thought for this explainer. Before you spend the significant time and money seeking a patent in today's fiercely challenging environment, you need to take a really hard, objective look at your own invention. You got to ask yourself, is your software simply automating a business tool or a human task on a generic computer? Or is it a true technological leap that fundamentally improves the architecture, security, or efficiency of the machine itself? Your honest answer to that question will likely determine whether you survive the brutal legal hurdle of Section 101. Thanks for joining me, and keep innovating.